So welcome to this evening's event. I'm Michael McConnell. I'm the faculty director of the Constitutional Law Center here, and it's my pleasure just to introduce our speakers for this evening and then go sit and enjoy the program. So our principal speaker, Cass Sunstein, is an old friend of mine from our days at Chicago. Now he is at Harvard Law School, and he writes just about as many books as fast as I can write an article or even an op-ed. So it's pretty, his CV is too numerous for me to recite in an introduction. And he is also just prolifically diverse in the various fields that he operates in. And tonight he's going to be talking about how to choose a method of constitutional interpretations, an issue that he and I have been arguing about for, 40 years maybe? I don't know. And then two distinguished commentators. On Cass's right is Larry Kramer, our former dean, and now the president of the Hewlett Foundation. And then on his right, Michael Ramsey, who is is a professor at University of San Diego and is one of the leaders of the Center for Constitutional Originalism there. And he's editor of the Originalism blog, and so he is very much a leader in the debates about constitutional methodology. So welcome to all of them. And then my colleague now, Bernadette Meyler, is probably known to most people in the room, and she is, among other things, author of a very interesting article called Common Law Originalism. And she is going to be the moderator for tonight's discussion. So please join me in welcoming these speakers. Yes.
Okay, well, it's a complete thrill to be here for multiple reasons. First is the amazingness of the students and faculty at Stanford Law School is an inspiration to everybody. You don't hear everyone's applause and awe, but it's there. To see my young friend, Michael McConnell, from whom I've learned so much over the years, who's a beloved friend as well as a source of knowledge and clarity on method and substance and how to be in the world. Also to be joined on this panel by amazing scholars, people from whom I've learned a great deal over the years, and the best student I've ever had, Larry Kramer, even though he's not a whole lot younger than I am. He is the best student I've ever had, and his career has been magnificent to see, and I'm just grateful to be here. Also, I'm thrilled to be here because this is the first time I'll be presenting the beating heart of a book in progress. It's en route. And to see your reactions is something I'm extremely curious about. And this is the only time in my career that I have the following aspiration, which is that the thesis will be one on which there will be general agreement by the close of the proceedings. That's unrealistic in the extreme, but it is my aspiration. Okay, my topic really is how to choose a theory of interpretation. That's not a Trojan horse. That's the thing itself. I'm going to be agnostic on which theory is best. No rabbit is going to be pulled out of any hat. During the process of doing this book, I've had a significant change of heart on the question at issue, meaning less clarity, much less clarity that originalism is wrong, something I used to feel clear on, a sense of the contingency of our accounts of what theory of interpretation to adopt, that it depends on things, which is not to say that we should hold our convictions lightly, but which is to say we should recognize the contingency of our convictions, and a sense of more calm and less heat with respect to the debates that are in some ways kind of tearing our United States apart. So we post a signpost: no tribes here, enough on tribes; no teams here, enough on teams. A target of the remarks is a claim of compulsion with respect to a theory of interpretation. So what these remarks will not be for, that's a gentle way of saying what these remarks will be against, is the view that a theory of interpretation, whichever you like best, is compelled by something. So the illusion of choicelessness is what these remarks will be challenging. The view that a theory of interpretation is, in some sense, compulsory is sociologically really interesting, and it's politically interesting, but it's not promising in principle. I'm acutely aware that's abstract for now. It's going to be less abstract soon, I promise. So a thesis, a short answer to the question posed by the title, is what makes our constitutional order better rather than worse. That in deciding whether to be moral readers or democracy reinforcers or originalists or Thayerians, and I'm going to try to specify that at least a tiny bit, the only game in town is the game signaled by that question. That's all I have to say. You're going to hear more words, but in terms of substance, that's the only thesis I'm going to present to you. A specification of the thesis is that each of us, in deciding on our theory of interpretation, must reach reflective equilibrium in which our judgments are brought in order. And I'm going to specify that more, I promise. Which judgments? There are general ones, like the rule of law matters, and there are specific ones, like people can disagree what the President of the United States thinks. Any theory of interpretation that is, let's say, fatally incompatible with the rule of law has a severe burden of justification, and any theory of interpretation that leads to the conclusion that Congress can forbid people from dissenting from what the president thinks, that theory would also have a very heavy burden of justification. When people disagree on what is the right theory of interpretation, what they are disagreeing about is what produces the right kind of reflective equilibrium for them. That's what they're disagreeing about, which suggests the contingency of any theory of constitutional interpretation. There is a world in which Thayerism is best, where Thayerism is understood as the view that the acts of Congress should be upheld unless they are clearly and unambiguously unconstitutional. No justice on the Supreme Court is a Thayerian, but we could imagine a world in which that would make sense. And I'm going to say something about what it would look like. There is a world in which, based on assumptions about judicial and legislative capacities, moral readings from the Supreme Court of the United States ought to be embraced as the right foundation for theories of interpretation. So on certain assumptions about institutional understandings, a standing ovation for Ronald Dworkin. There's a world in which originalism is best, and one in which democracy reinforcement, which Justice Breyer basically has embraced a version of that, is best, and we're getting ahead of ourselves. Reflective equilibrium, I suggest, is where originalism stands or falls, where moral readings stand or fall. Moral readings as reflected in Griswold, the contraception case, Roe, do I need to tell you, the abortion case, and Obergefell, the same-sex marriage case. These are moral readings of the Constitution, and reflective equilibrium is where democracy reinforcing approaches to judicial review, and Brown against Board of Education is frequently understood in those terms. That's where democracy reinforcement stands. Okay, now let's get a little more concrete. Here are 7 of the actually 13 players, but for the sake of brevity, there are 7 candidates. For theory, I'm being a little mischievous here, but here are 7 candidates. One is semantic originalism. We follow the semantic meaning of the Constitution, so that if the word equal turns out to mean the name of a sugar substitute, as it does, you know about equal protection of the laws would not have anything to do with sugar substitute protection of the laws. So semantic originalism means we follow the original semantic meaning. That, in my view, is a very agreeable understanding of the Constitution. It's not very provocative. It leaves a great deal of open, yes? You can use the semantic meaning of the words equal and think affirmative action is constitutionally compelled, think affirmative action is constitutionally forbidden, or think the Constitution has nothing to say about affirmative action. Public meaning originalism is what cool kid originalists now embrace. It is formidably defended by Larry Solom, among others. It is more provocative because it uses contextual enrichment in a way that leads to a much more constraining understanding of constitutional provisions than semantic originalism would mean. At one point, people embraced original expectations originalism, where you think, what was the founder's expectation about the domain or scope of a provision? That's a little bit on the run in the originalist universe. It is a candidate, and some justices currently deploy it. Democracy reinforcement is basically a working theory of what the Warren Court was all about, protecting voting rights and rights essential to self-government, and protecting rights of groups that were systematically at a disadvantage in the democratic process. John Hart Ely defended that view, I think instructively dedicating his book, and movingly, to John Hart Ely, saying, paraphrase, you don't mean many heroes if you choose well. Just Warren. Okay, moral readings are giving a morally favorable interpretation of open-ended terms. Justice Frankfurter toyed with moral readings, and Ronald Dworkin defended that. David Strauss has called for common law constitutionalism, an approach to the Constitution that sees it as case by case, building up a little like tort and contract law, giving that a kind of Burkean flavor. And Adrian Vermeule most recently has defended common good constitutionalism. Am I speaking Greek, or are these familiar categories? Okay. Note there are incomplete theories. Theorism, which says you uphold legislation unless it's obviously inconsistent with the Constitution, requires a theory of meaning to get the theory and apparatus added, but it certainly strikes a mood. Burkeanism, which says let's respect the past. That is also an incomplete theory. And something I love, and as theories go, kind of am married to, is minimalism, which says go case by case, don't be theoretically ambitious, don't be wide, don't overshoot, and that is an incomplete theory. Okay, the Constitution does not contain the instructions for its own interpretation. So if we're committed to the Constitution or this Constitution, as those of us who've taken the oath of office have done, it's not clear from the face of the Constitution which of the sensational 7, let's say, we are bound by. maybe semantic originalism we're bound by, but maybe not even that, and we can discuss that a little bit in a moment. What's most important here is to say that the Constitution lacks a theory of interpretation on the four corners of the document, which is to say that the theories just stated are all candidates. To speak in terms of what interpretation necessarily entails, or what legitimacy calls for, or what self-government demands, is, with respect to the seven contenders at least, a dead end. Interpretation can be many things. I received a somewhat unfriendly email today, only one unfriendly email. It was a good day, from someone who said that interpretation necessarily calls for originalism. It isn't so. You can be an interpreter of Shakespeare or Brown against Board of Education who doesn't ask what was the original public meaning of Shakespeare or Brown against Board of Education. The word interpretation admits of multiple accounts. Legitimacy is often foot stomping and a placeholder for something else, and a democracy reinforcing approach to judicial review proclaims its self-evident legitimacy. I think that's too strong, but to say that it's illegitimate compared to, let's say, public meaning originalism or moral readings, that's a very hard argument to make. Democracy is compatible with multiple different approaches. Which of the contenders I stated is better on democratic grounds? The broad concept of democracy won't tell you. Moral readings are the most contentious, I think, from the standpoint of those who are concerned with judicial self-discipline, but they do not ignore this Constitution. They claim to identify its meaning. Still, there are problems, which is people who understand themselves as moral readers might be immoral readers. Think of judges understanding the Equal Protection Clause or the Free Speech Clause in ways you find abhorrent. You might not be excited about them as moral readers, yes? You might be terrified about them as moral readers. So we might want second-order moral readings where judges would adopt a principle of self-restraint so as not to give free rein to their own moral compass. Okay, so that's just to suggest moral readings is a candidate, but there are problems. Okay, a quote from John Rawls in thinking about moral and political philosophy: there are some questions which we feel must be answered in a certain way, and Rawls urges in figuring out what justice requires, there's no escaping asking whether we think slavery is wrong or torture is wrong or something abhorrent is wrong. If we think that a question must be answered in a certain way, that imposes a lot of pressure on us in discerning what our favorite theory of justice is. I suggest that whether or not Rawls is right about political and moral philosophy, this is the only game in town for the question these remarks pose. And I'm going to use a quotation from a superb book by Randy Barnett and Evan Berwick, who urge in defending originalism in a book called The Original Meaning of the 14th Amendment, we do not believe that adopting the original meaning of the 14th Amendment as a whole would lead to results that differ radically from those that current doctrine would produce. Far from it. Remember that, if you would? That is, I think, a diagnostic sentence in a book defending originalism. Are you with me? That they find it useful, at least, I would say essential, to say some version of that, which is to suggest that we go forth and back and forth between our fixed points and the theory to see if the theory stinks. Here are some possible fixed points: Marbury against Madison, Brown against Board of Education, free speech holdings, Griswold, maybe, Heller, maybe, the gun case, not Heller, maybe, the steel seizure case. If a theory interpretation would lead to the incorrectness of Brown, the trivialization of freedom of speech, the non-existence of a right of privacy, many people would plausibly say, I don't like that theory. And that's quite fine. There's nothing else to say except that, and to have a discussion about that. Words like interpretation, legitimacy, and self-government are too abstract. I think Justice Scalia, in his best moments, was right on this point and participating in this discussion. There are abstract ideas, too, a theory of interpretation that leads to great discretion for judges is, Houston, we have a problem. One that compromises the rule of law, understood as predictability and generality, also creates a problem. And one that severely compromises self-government, that's a problem there as well. So briefly put, in choosing among theories, we cannot possibly ignore or refuse to attend to fixed points, even if they are subject to revision. For each chooser, I'm not getting choked up, I've just got a little frog in the throat. Okay, I was starting to cry. This is moving to me. For each chooser, each one of us, a judgment has to be made about what those fixed points are and about whether one or another approach would endanger them. So in a way, what I'm saying, I think, is an invitation and not a provocation, because it is leaving ground open for all of the 7 candidate theories. But it's suggesting this is the terrain on which battle must be done. There isn't another terrain on which to do the battle. If Brown or freedom of speech is suddenly doubtful, that's necessarily a problem. It's not necessarily a decisive objection. Whether it is one or the other depends on the magnitude of the losses and the benefits of the gains. So let's start driving the car home. I said there is a world in which originalism makes sense. If the original public meanings are wonderful from the standpoint of institutions and rights, originalism is starting to look golden. If we have stinky judges who are good at history, but stinky at, let's say, moral readings, then that's another point for originalism. If originalism leaves short certain rights and democratic processes would make up the difference, then go for it, originalism. We can move along various margins in these 3 bullets and still be originalists. It might not be that extreme. Is this clear? There's a parallel universe, maybe a Black Mirror episode, or maybe our universe, in which we're close enough to this for originalism to make sense. But this is meant to suggest not something about originalism, but each of the 7 candidates altering assumptions about the capacities of institutions. Is this clear? Thayerism would be wonderful, where judges maybe are confused or unreliable, and legislatures are great. Then we would want Thayer's principle, strike down only if the invalidation is clear. That would be a world fit for Thayerism. Moral readings, you just have to move the dials a little bit, and Dworkin starting to look good, and democracy reinforcement too. This is a pretty fun game, and anyone can play. I am not an originalist, I will say, though that's not the burden of these remarks, because in my view, bowling against Sharp, forbidding racial segregation by the federal government, and racial discrimination and sex discrimination by the federal government, for me, the fact that they are not defensible on originalist grounds is a really serious problem. A world in which the federal government is not bound by an equality principle is, in my view, inconsistent with fixed points. I hope that's true for you too. If not, fine, we're still playing the same game and just disagreeing about how to value the problem. Brown, in my view, is extremely challenging to defend on originalist grounds, notwithstanding Professor McConnell's heroic efforts. My view of the history is Brown cannot ultimately be defended. Whether or not that's so, the best current work suggests the principle of freedom of speech starts to get really, really small. There's superb work by Judd Campbell suggesting on originalist grounds the original public meaning of the First Amendment is a very small principle compared to the one that Americans are blessed to have. The Due Process Clause, Larry Solem, in a very impressive and, in my view, disconcerting article, finds that the Fifth Amendment's Due Process Clause not only would not defend Goldberg against Kelly, allowing welfare beneficiaries to get hearings, not only would eliminate substantive due process, but wouldn't even require procedural due process. All as it is a notice provision. All it requires on this more than plausible account is that you get notice that your property is going to be taken. That's an unacceptable understanding of procedural due process. What kind of constitutional order would originalism produce is crucial to the question whether to be originalist. And if the historical account just given is incorrect, then originalism is starting to look better. But this is not a point about originalism. It's a point about the task of evaluating constitutional theories. Fixed points operating at multiple levels of generality are the only game in town. Okay, that is what people are actually disagreeing about, I suggest. Everything else is smoke and mirrors, which gives us clarity on how to mediate the disagreements, and maybe better, how to do that with more of a sense of mutual respect. Thanks.
Can I close this? Okay, I want to move this also because let's see if that works. Cass didn't mention, we were all colleagues together at Chicago. He was actually, his first year in teaching was my first year in law school. And some of my favorite memories, actually, I think my favorite memories in law school, my third year, I did an independent study with Cass on law, religion, and interpretation. And it's still like one of my favorite things I ever got to work on, although I never published it because it would have been embarrassing. And I mention that because, so I want to start with a little story. Morgan forwarded two papers ahead of this session. One was entitled Fixed Points in Constitutional Theory, and I think is a kind of first cut at the book Cass is talking about and was the main topic, the basis for today's talk. The other, more tangentially related, was entitled Theorism. So I read Theorism first, and I wrote Cass an email about the history behind that paper, which is something I had studied. And at the time, I'd only looked at the abstract for the Fixed Points article, and we slipped into an exchange on it anyway, leading to a really important lesson for everybody, which is don't get into an exchange with an author based on an abstract if you haven't read the article. Because from the abstract, I assumed Cass had written a piece to explain, why some theories of constitutional interpretation are better than others, and thus inviting a conversation along the same lines. So I was puzzled by his reaction, which after a few go-arounds led him to say, we should just end this exchange because you're totally missing my point and you're making me feel, quote, horrible. As if I wasted my time even trying to write this. Ouch. Which, as I say, so we were colleagues, we've been friends, but there's still this sense in which, Daddy, and it was really crushing to me. So I immediately sat down to read the text, which does, in fact, make an argument that is rather different and unexpected. And I had to read it a couple times because of that before I came to a conclusion about the object of the article. But as Cass said clearly here, he's not taking a position for or against any particular approach to constitutional theory or interpretation, and rather making a point about every approach to constitutional interpretation, but one that is neither for nor against any of them. Now, if any position in constitutional law is shared, I think, across the field, it's that a theory of interpretation shouldn't be results-oriented. Whatever else you might say about how to interpret the Constitution, everyone agrees, and here I'll just have a quote from Cass's paper, that the choice of a theory of interpretation cannot possibly depend on the results that it yields. That choice must be made on the basis of some commitment that might seem more fundamental or binding, to which Cass says in this paper, wrong. Right? The choice of a theory of interpretation must necessarily be results-oriented, at least in the sense that any theory must conform to firm convictions about certain outcomes. Meaning, I think, that the difference among theories is ultimately and unavoidably driven by differences about the results one prefers and must be justified or not on those grounds. So No one has the high ground on theory, and the goodness or badness of every theory is a contingent matter of how well it supports a set of critical outcomes, which is a, actually counterintuitive claim. Now, Cass sets the stage for that by analogizing, and he touched on it here, although he does more in the paper, by analogizing the problem of constitutional interpretation to problems of moral or political theory, and in particular drawing on Rawls's notion of reflective equilibrium. And I confess, I find that way of thinking completely attractive and compelling, though in philosophy I associate it more with, and this, I mention this only because like almost everything I've done and thought over the years has been drawn on this, I associate it with the late 19th century writings of William James and pragmatism. Right? On the Jamesian view, our thinking and actions are guided by a complex web of interrelated beliefs and practices, which we do our best to keep consistent. The complexity of the web is such that tensions invariably exist, and we can go a really long time operating inconsistently without even realizing it. But something happens that calls our attention to an inconsistency between our beliefs and our practices, and then we cannot help but take some kind of action to resolve that inconsistency. So that might mean changing a belief to sustain a different belief that we still hold. It might or to maintain a practice that we still like. It might mean changing a practice because of our commitment to a belief, whether an old one or a new one, and so on. But the best and most we can do to find our way to truth, in the Jamesian terms, that is to correct action or belief, is to determine what best maintains consistency in the most normatively compelling version of our web, which I think is essentially the same position that Cass is taking. And he argues that this way of thinking applies equally to constitutional interpretation. And I should note in passing that much seems uncontroversial to me. In fact, that way of navigating law is in fact the very essence of traditional common law reasoning. It's, for instance, precisely the process described by Edward Levy in his classic Introduction to Legal Reasoning, which I bet no one here has read. How many of you have read? Oh, well, yeah, it's a generational thing. You should read an Introduction to Legal Reasoning by Edward Levy. And even in constitutional theory, it's actually pretty analogous to Dworkin's theory of constitutional interpretation, which does require a similar tacking back and forth between what Dworkin calls fit and justification. And we tend to leave out the fit part and focus on the justification, which is the moral reading side. But Dworkin really did, at least in theory, have this notion that there are a set of outcomes and your justifications have to go back and forth between it. So it's analogous in that. So Cass's point, if I understand it, is that a judge will necessarily hold some set of fixed points, or we just call them commitments, about the law. And like Rawls's fixed points of political theory, or the core beliefs and practices of ordinary citizens and people, those operate at different levels of abstraction and specificity. Some in law can be broad theoretical commitments to something like democracy or tradition or judicial restraint. Others may reflect settled judgments about the constitutionality or unconstitutionality of specific practices. Cass gives examples like race and gender discrimination, abortion, gun ownership, and the like. And Cass is clear, by the way, in the paper, and I don't think you were as clear here as you might have been for the audience, that he doesn't simply, this is not about preferred results. This is just not about the results that I like. It's a smaller set of more fundamental commitments about what a good constitutional order is built upon or requires, and I think that's a really important point to bear in mind. So, okay, so that's a kind of recapitulation, and I just want to note two things about the fixed points or commitments in Cass's telling. First, it's important there is no agreed upon or established list of what they are, and they can be different for every different person or judge. And second, the choice among theories of interpretation must necessarily depend on how well or poorly a particular theory does in coherently lining up the particular interpreter's fixed points or commitments. So the choice of a theory of interpretation is necessarily then results-oriented and in a very real sense. Whether it's one of the multiple versions of originalism that have emerged, Dworkin's moral reading, Eli's democracy reinforcing approach, any other theory, the choice is going to be driven by whether the theory will or will not generate some particular set of results that the person choosing thinks are necessary for a good constitutional order. And of course, the particular results can differ from judge to judge or interpreter to interpreter, but that's still just another way of saying it's still results driven for everybody. Now, when I first read it, I thought Cass might be driving toward a kind of radical relativism, right? As if he were saying that since all theories are result-oriented in this sense, they're all equally good or bad. but I think he was clear here that that's not what he's saying or means, right? It doesn't follow that because different judges can have different fixed points, any choice is as good as any other. We can and must still argue about which fixed points make for a better or worse constitutional order. And as he said, that's just not the argument that he's engaged in here. That would be the next argument we have to have. He's arguing that that's what all the disagreement is about, though. So let's just face up to it and deal with it accordingly. Okay. So I want to raise 2 points in the argument that I think need clarification, and then a couple of challenges. So first, I think Cass presents the need to seek reflective equilibrium as a necessity. Right? He says it's more than just a sociological fact. It's something that necessarily inheres in the very process of choosing and applying a constitutional theory. But is it? It seems to me people can and do routinely live quite happily with inconsistency in the form of exceptions to their commitments. So, for instance, a judge might adopt a theory of interpretation like, say, public meaning and originalism for a reason like, say, a theory of positive law combined with the idea that Article 5 is the appropriate way to change undesirable results, and then make exceptions to that approach in contexts where it conflicts with some other value or commitment, as many originalists do, and as I think they're about to do again, say in the context of affirmative action. After all, commitments, even our most important ones, don't have to all be equal. Right? Some are still more important than others. Moreover, they may be more important for reasons that are incommensurable. So I'm committed to an originalist jurisprudence because based on my understanding of law and authority, because of my understanding of law and authority, and that jurisprudential commitment is strong enough to outweigh most of my substantive commitments most of the time. So in most cases, I'm going to stick with original intent, understood that way, and wait for the people to correct me through Article 5, even when I don't like the result. But some values, say my commitment to some idea of colorblindness, are more important than my jurisprudential commitment. So when they come into conflict, I go with the more important commitment. Judged strictly from the perspective of an articulated theory of interpretation, it's an inconsistency. But, like the Kantian who would still lie, if it were to prevent a whole lot of people from being killed, I do it anyway. My normal theory covers most cases, but I'm open to exceptions, even if their intention judged from the perspective of consistency and coherence. Now, I'm not sure what to make of this. It's such a commonplace in courts and in life, though, that I think Cass needs to address it. And there's, several possibilities. We could just dismiss it as hypocrisy. That's what most people tend to do when they argue about originalism. We could simply move up a level of generality and say, no, but the real theory of interpretation is more complicated and ultimately still results-oriented. Maybe there's some way to put that together. Or does it suggest that the argument about what any and every theory of interpretation must do is in the end just another argument about what a good theory of interpretation should do, in which case there's either a missing normative argument or it's just another version of the kind of arguments we've already been having. Okay, second, for clarification, I think, and this is one where I just think Cass needs to be more explicit about an aspect of the argument that I found unclear, namely that it requires some of the fixed points to be specific outcomes. So one of the, Cass illustrates the argument using originalism. Assume, he says, that originalism, in whatever form one adopts it, would mean that Brown and Bowling are wrong, that race and sex discrimination are permissible, that government can punish lots of speech, and so on. And like he says, why would anybody want to be an originalist if it would lead to a constitutional order that would be so vastly inferior to the one that we have? In the paper, and here he touched on it, he then notes various ways in which originalists might respond, such as working stare decisis into their theory or arguing that originalism actually supports many of those outcomes. But one response in the paper, he says, goes for the jugular of his argument. And that response is that originalism is mandatory, that it is, quote, the only legitimate approach to interpretation and is justified independently of the outcomes it produces. Now, originalists might have different reasons for saying why that's so, and it might be that they can only do so by reference to some other independent value like positivism or democracy. But as a reply, it's comfortable giving no weight to, again, to these provisional fixed points about particular holdings and making its approach to interpretation the only fixed point. And to that, Cass says, and I'll just read a quote, "Those who make such defenses might be willing to recognize that the result is to question or jettison some holdings that are regarded by many, or perhaps they themselves regard as provisional fixed points, Nothing said here demonstrates they are wrong. The only goal is to expose the grounds on which they must defend their position and some of the questions that they must be prepared to answer. But I think there has to be more to it than that, because the originalist in this example has done just that. Right? He or she has identified their version of originalism as the only fixed point that matters and given a reason for it, that it follows from positive law and democracy. Now, a critic might want to challenge that by pointing to the negative outcomes, to which the originalist might answer that I don't agree that they're negative, or if they are negative, they can and should be changed through democratic processes, and a constitutional order that changes that way is better than one that doesn't. The critic might find those arguments unpersuasive. I do. But again, no, we're just back to the same kinds of arguments we've been having all along, which I think is to say that for the argument to really have bite, I think it requires that there be at least some fixed points at the level of particular cases or outcomes. To be valid, a theory of constitutional interpretation must be able to account not just for a process in the abstract, but for some set of specific results in the world that the person endorsing the theory is prepared to defend as right and just and better than the alternative. And if that's so, and again, I think it has to be, why is that so? Right? Why can't one adopt and defend a theory of interpretation that accepts provisionally bad results and relies on process arguments, like amendment or something, to address them? Which leads me to a final question about who Cass is responding to here. So, and that's, I only say that because I actually don't think anyone arguing about constitutional theory approaches it as a purely abstract question, as if there's some inherent notion of interpretation that has nothing to do with the outcomes it produces. Now, that's not to say that nobody argues that way, because people do. There are people who argue that their favorite theory of interpretation is inherent in law or inherent in text. But along with Cass and Rawls and I think William James, I'm pretty sure they have intuitions about outcomes and are driven partly by a sense that their theory generates desirable ones, in which case Cass is essentially calling for them to at least be open about that and make it an explicit part of the argument. But I'm not sure what that gains us, because the provisional fixed points reflected in specific outcomes are not the only thing that matters, as Cass recognizes. They're part of what's needed for a good theory of interpretation, but so are fixed points about how to interpret, and so are fixed points about less specific but still important substantive commitments like democracy or traditionalism. Plus, there are multiple approaches we might take that will fit these different kinds of commitments in different ways that might be better or worse. That is, Cass's argument is, as I think he acknowledges, underdetermined in that we still have to iron out disagreements about all these different points and how best to fit them together. Especially since, we also care about the sense of how the theory is going to work out in all those other cases that are not fixed points, but that are still going to matter in the ongoing process of interpreting and implementing a constitution. But, as I thought about it, I thought, but that is, I think, what we've been doing all along. That is to say, we have disagreements now about the nature of law and legal interpretation. We have disagreements about the most important substantive values our Constitution should be interpreted to promote. We have disagreements about which specific results are the most important ones given those values and which approaches do the best job, realizing them and so on. And that's what debates over constitutional interpretation have been about, which suggests, and this will be my last point, that the real problem may be the idea that we need a theory of interpretation at all. As Cass notes, we can imagine a world in which any theory might make sense because of the constitutional order it produces or the outcomes it produces. But when you think about the world we have, which is one that is constantly changing and in which the changes are partly produced by the results of our ongoing constitutional decision-making, maybe the mistake is in thinking that we need a or any theory of constitutional interpretation in the sense Cass has been talking about, which is to say in the sense of all these theories that he mentions. This is the point Michael and I have talked about. Bear in mind, that whole notion of constitutional theory, interpretation theory, is recent. It's something that emerged only in the 1960s after Brown and in the wake of the court's successful bid for supremacy in the interpretation of the Constitution. There was no such notion across most of American history, nor even any formal debate about how to interpret a constitution. There was, rather, simply a variety of techniques being employed by different interpreters in a broad, generally shared, and very flexible practice in which a kind of all things considered approach was taken. An interpreter could and did look in an open-ended and unstructured way at the text, the history, the purpose, the precedent, the past practice, the structure, and so forth, from which they would develop an argument for what seemed in context like the best overall interpretation. So not a theory, just a set of considerations to look at in trying to reach the most persuasive result. A kind of general forensic approach and that approach was universally accepted among lawyers, judges, legislators, and ordinary citizens. And that worked in a world in which the court's interpretations of the Constitution weren't final, right? In which the idea of judicial supremacy wasn't accepted, and the political branches could and did push back when the court went too far, went in the wrong direction through things like court packing, jurisdiction stripping, budget slashing, and the like, and in which Congress's capacity to do that actually exercised a constraining force on the court in the first instance. So it was a really pragmatic approach that treated the Constitution essentially as a form of customary law refracted through a text. Just our understanding of the text would just evolve in a customary way over time. That changed only in the years after Brown, when the left, the traditional opponents of judicial supremacy, flipped to embrace it because they liked what the Warren Court was doing, while the right, the traditional supporter of supremacy, adhered to it. And suddenly everybody agreed that the final word lay with the justices, which was operationalized by the delegitimation of all those devices that were traditionally used to push back, like court packing and budget stripping and jurisdiction, budget slashing and so on. And as that happened, the question of how to interpret the Constitution, as the court's word, right, became final with the justices, the question of how to interpret the Constitution suddenly became imperative, because you had pulled out that pragmatic process in which every branch of government and all of the people in the country participated. And we got this flowering of theories and debates that Cass is addressing, which suggests that perhaps the mistake is the embrace of judicial supremacy. Maybe we should let go of that and go back to a world in which our approach to the Constitution doesn't need to be localized in one branch, which then needs some kind of abstract theory to justify its power. Now, that doesn't mean giving up the idea that the Constitution is law, as you see from the experience of the first 150 years of this country. How to recover that, what that would look like, is a topic for a different talk. For now, I'll just note that it's consistent with Cass's sense and may even be what he is suggesting, though I think one of the key differences, at least for me, is it's an anti-foundationalist approach. It really begins with the notion that there is no foundation, fixed foundation for this. Thank you.
Well, thank you very much for having me. Thank you to the organizers for inviting me to come up to this wonderful event, and thank you to all of you for coming to hear us talk. And it's great for me to be back here at Stanford Law School, where I was a law student many years ago when dinosaurs grazed on the back paddock and Paul Brest was a dean rather than a building. I think the reason I'm invited here is to give an originalist perspective and response to Professor Sunstein's remarks, and so I'm going to try to do that, although I want to emphasize that it's an originalist response or an originalist reflection on this, not the originalist perspective, because I think different people who are attracted to originalism would have different responses. But here are some thoughts that I have. The first is that I agree with the central assumption or central thrust of this project, which is that it's a normative choice as to what role judges are to have in constitutional adjudication. Unlike some originalists, I don't think that it's anything compelled by the particular constitutional structure, the way the Constitution is written, or anything like that. Whether or not the Constitution contains rules for its own interpretation, we can decide to disregard them if we would like. So unlike that, now it's different from some originalists, such as, for example, Christopher Green, who's one of the leading sort of voices on the other side, and perhaps to some extent what this article is directed against, who do think that there's a compulsion as to what we should pursue in terms of constitutional adjudication. But I agree with Professor Sunstein that it's a normative choice. I wouldn't call it a choice about interpretation, though, because I think there's too much disagreement about what it means to be interpreting something. And in any event, I think it doesn't matter whether we're interpreting or doing something else. The question is, how should courts and other government actors, but in particular courts, act in deciding constitutional rules, regardless of whether you want to call that interpretation or something else? So that is the way I see the question, is what is normatively the most attractive way for us to structure constitutional adjudication. So the question then becomes, in thinking about that, should we think about fixed points in terms of particular outcomes? And I think this is the central point of the presentation where I don't agree. But that is the claim, as I understand it, that in making this normative choice that I'm describing, Professor Sunstein is describing, that we must think about particular outcomes. And my answer to that, subject to a caveat, and I want you to remember that there's a caveat coming at the end, but subject to the caveat, I think the originalist answer to that, and this is anticipated by some of the remarks that Dean Kramer gave us, and some of this will be familiar from what he just said, as he very ably anticipates what an originalist might well think, even though he's not an originalist. But for an originalist, I think, the fixed point is not any particular outcome, but it's a structure of the role of courts, and that the role of courts fundamentally is not to impose their own moral and policy intuitions, but rather the role of courts under the rule of law in a separated power system is to apply the enacted law, by which I mean the law given the meaning that it had at the time that it was enacted. And that fixed point at the higher level of generality takes precedence over particular outcomes, because particular outcomes may be better, some particular outcomes under the system may be better, others may be worse. But what we are really talking about is the larger structure of the way we want courts to do adjudication. And so the originalist says we want courts to do adjudication in a way that doesn't involve them imposing their own values. Now, I don't have time to justify that claim, so I will just assert it and leave it there as what I have come to see as the central fixed point of originalism. And Professor Sunstein anticipates this in the paper on which the presentation is based. He says we would embrace originalism. He is making an argument on behalf of originalists here, which he doesn't believe, but he does a very credible job of anticipating what the originalists would say. We would embrace originalism not because it's the only legitimate approach. That, I agree, is not the only legitimate approach, but because it is justified by some independent value, regardless of the particular results that it unsettles or questions. And that independent value for originalists, I think, is the rule of law. And I think a key to making this conclusion is that we are not talking here about the fundamental moral bases of society, about deciding what those shall be, but rather we're just talking about the role of judges in implementing moral and policy decisions. So, for example, to take the abortion cases, Roe and Dobbs, you might think at first that the question is whether there should be or should not be a right of access to abortion. But really, in the cases, the question is whether a court should enforce or prohibit such a right. So stated, you can see the general question, if the courts don't become involved, is left to the democratic process. So we are asking when should not what the answer should be, but when should courts intervene to impose an answer? And the result of thinking about it that way is that the structural question of what the role of courts should be takes precedence over a particular outcome, because we're not really talking about a particular outcome in terms of what the answer society gives is. We're only talking about a particular outcome in terms of what a court will or will not do. And if the court doesn't intervene, then the answer is supplied elsewhere through the democratic process, through constitutional amendment. As, for example, it's done in other countries where these decisions are not constitutionalized. Other countries with very respectable democracies, very respectable rights, but not constitutionalized. So that's the question, to me, is not so much what the ultimate moral answer is, but who is going to supply it? Courts or some other part of the system. Now, let me get to the caveat. I do think that originalism depends on a certain basic minimum level of moral acceptability in the outcomes it produces. I don't think it requires us to say that it will be wonderful, but I do think it requires us to conclude, to look at the landscape it would produce and say that it is not abhorrent, that it is not tyrannical. So to that extent, I further agree with the presentation. I don't think, however, that that's achieved necessarily by looking at particular outcomes, but rather looking at sort of the more general, the general results that would be produced. I think that, though, that originalism does meet this. I'm not going to defend any particular outcomes, but I would say that when we're talking about most judicial theories of originalism, in any sense, in any case, there are some academics who would not agree with this, but there are academics who think a lot of things. Originalism is really the original meaning joined with a respect for precedent in terms of cases that are deeply entrenched and not widely controversial. There are a set of cases that most originalists would not question, not because they're rightly decided, but because they're so entrenched into the legal system. Justice Scalia said that they're woven into the warp and woof of constitutional law. And I'm not enough of a weaver to really know what he was alluding to there, but I think it has to do with they're just so embedded that it would not be in anyone's interest to overturn them, including it would not be in the interest of originalism, which is fundamentally a theory about the rule of law, stability, and predictability. So I think when you're thinking about the results that originalism produces, you have to think about it in terms of originalism plus fidelity to precedent of that sort. It's not about all precedents, but it's about core precedents, like I would say, for example, Bowling is an example of a case that would not be overturned in this sense. So I think that you look at originalism and you say, does it meet this minimum threshold? If it does, then the value of the rule of law, which is the fixed point to which originalists are driven to and are not going to give up, I think that does overcome any particular outcomes, because particular outcomes can be fixed through the democratic process. We're not talking about a final answer. We're only talking about the question of whether courts are the ones ultimately to make the decision. I want to add one final point, which is sort of tentative. So I have not really thought about this for sure, but it's inspired both by Professor Sunstein's presentation and by Professor Kramer, Dean Kramer's remarks. I think it is possible to imagine originalism with an escape valve. That is, originalism, but with the caveat that if it produces an abhorrent moral result, then originalism would not be followed. I don't see any reason why that couldn't be a theory. What I want to emphasize about that is if that theory, if you want to adopt that theory in order to get around the idea that certain fixed points in terms of outcome would be violated by originalism, then you can have this escape valve. But I don't see how adopting that theory, which solves the abhorrence, perhaps, if there is such a thing, of certain originalist outcomes, then allows, or even encourages, an abandonment of originalism as to other areas. And here is where I think, to the extent there is a rabbit in this presentation, I think maybe this is where it might be, that if you feel compelled to abandon originalism to reach a particular fixed result, particular outcome that is a fixed point, why is that then justify abandoning originalism and its benefits for the rule of law in all other cases? Why doesn't it just compel you to abandon originalism to reach your particular fixed point? In any event, that's all I'm going to say about this, except to thank Professor Sunstein for this wonderful presentation, which to me, I think I benefited enormously from this in thinking about what the presentation is saying and what it is calling upon us to think about, in the sense that I think I understand better why I am inclined to be an originalist. Because he asks us to say, what are your fixed points? And I think my fixed point that leads me to be an originalist is this idea that judges should not impose their moral preferences and intuitions upon the rest of us without a mandate through enacted law. That's my fixed point, and I understand better from hearing this lecture why that is the core of my originalism. So thank you for that, and thank you to all, and I look forward to your questions.
Thanks so much to Professor Sunstein and to Dean Kramer and Professor Ramsey for your wonderful remarks. There's enough here to spend another hour on discussion amongst the panel, but I want to make sure that we get to some questions from the audience. So you might notice that there are 2 microphones here, so please go ahead and line up. We should have time for 1 or 2 questions from the audience. Just to get us started off, though, I had a question for all of you, really, or 2 questions. So one question that arises from the presentation in the paper about fixed points is why should we assume that the constitutional order as it currently is the best one? So does a focus on kind of fixed points lead us in an overly quietist direction towards assuming that we currently have the best constitutional order we could have, and to neglect some of the potential mistakes of past constitutional interpretation or the other potentials of future interpretation? So, do fixed points sort of skew us in a particular direction and bias us towards a particular pre-existing notion of the Constitution? And then the second question is that I think that this paper and project is very interesting, not only in and of itself, but also as part of what I see as a movement away from procedural and process-based views about the Constitution. And I think, as Dean Kramer suggested, we get a kind of self-consciousness about constitutional interpretation only relatively recently, within the past 50 years or so. And a lot of that time was occupied with kind of process-based theories of why constitutional interpretation should be justified based on according with a particular process. But I see now a movement away from that. I mean, maybe the most prominent would be Adrian Vermeule's Common Good Constitutionalism, but it seems to me that there are increasing numbers of theories that really present kind of substantive outcomes as what we should be thinking about when we're engaged in processes of constitutional interpretation. So I'm just curious if people also see that, that movement and what to make of it. So those are just two opening questions.
Great. So first, thanks to Michael and Larry for fantastic comments. They're extremely clarifying, and there's so much in them that I'm not going to even try to start to answer, but I will answer these questions, or try. Fixed points aren't precedents. They are things that you think are essential foundations for a constitutional order, such that a theory of interpretation that puts them in the trash can would have a very heavy burden of justification. So you might think, I think, that Brown and Bowling are two, and that it's not off limits to a constitutional theory to put them in the trash can, but it's close to that. If you think that, for example, your fixed point is the Constitution has to give minimum welfare guarantees, then, or it has to be inconsistent with Brown, or it has to be inconsistent with Roe, let's say 2 years ago, then go for it. Then you'd be in the right domain. So if you think the best understanding of our constitutional order is very different from the current one, that's admissible to you in concluding that there has to be a theory of interpretation that accommodates those views. And then there'd be discussions, yes, about everything that your view would entail. That's super interesting on process-based to substance. And I think you're right. And it's sociologically interesting why there were process-based theories. Ely was one. And I think there's one account of originalism that is processy, that doesn't go into whether the minimal threshold that Michael refers to, or I'd say it would have to be a little stronger than that. But Barnett and Bernick, I applaud them for saying that their understanding of the 14th Amendment would accommodate the essentials of current constitutional law. Now, I should say they don't believe that's essential. Their argument for originalism isn't there, but they think it's a nice point for them. I'd like to say, in response both to the second question and to both of the commentators noting that we didn't really think about constitutional theory for a long time, I'd like to say this is progress. That we're just like Olympic runners are faster now, and biologists know a lot more about biology now. Yes, and physics is way ahead of where it was. So is the understanding of law. So when Lochner was decided, or when, let's say, the precursors to Brown were decided, there was an implicit theory of interpretation in those cases. What was it? The fact that that question doesn't have an obvious answer, that's bad. So even if we had judicial review without judicial supremacy, we need a theory of interpretation that would undergird judicial review. And hooray that we're now at a point where we are, able to think hard and well. And the existence of common good constitutionalism or other substantive theories, whether you embrace them or not, they're contenders. And, at least we know we're talking about the right things.
Thank you. So I see there's a question over here. And when you ask a question, can you just introduce yourself, please?
Hi, I'm Sam. I'd like to thank you guys for an amazing talk. So there seems to be an agreement from the panel that the Constitution doesn't have very explicit or any explicit ways to guide interpretation. I was wondering, do you think this is a flaw? Do you think if you were designing Constitution today, would you put in specific rules of interpretation, or would it be ignored anyway, or would it be a fool's errand, or how would you approach that?
That's great. For me, and this isn't what the remarks were about, but I'd put in some version of Ely's theory of interpretation. That's more provocative, I think, than anything I said in the remarks, but I would favor
It's a little
that.
contrary.
It's contingent on assumptions, but the judgment is it's a good bet.
Well, I was going to say, I'm not sure that I endorse the view that the Constitution doesn't contain a direction of how to interpret it. I think that the framers' use of constitutional language against the background of the way they understood law being interpreted does, to some significant extent, carry with it the assumption of how they thought the Constitution would be interpreted. But my point is just that we don't have to follow that any more than we have to follow anything else that they said. If we decide as a society to disregard all or part of the Constitution, we can do that, and that's a normative choice. So I actually think that even if the Constitution did expressly specify how to interpret it, we could just disregard that in the same way that we have decided to disregard some other parts of the Constitution that say some express things. So I guess I don't think that you can solve this problem by putting in something expressed like that, even though it'd be nice if they did that, but I still don't think, I think we'd still be having the same conversation if they had.
I just want to make a couple of quick points to tie some of these answers, I think, together, including Bernie's original question. So, I think Cass's point would inherently include the fact that the fixed points can evolve. So it's not that we're locked into this constitutional order, but they don't evolve willy-nilly, and this is why, for me, the Jamesian notion makes more sense, because little pieces are moving around inherently no matter what, and as they do, then it's not surprising that fixed commitments would change. So, in an era where Plessy versus Ferguson seemed right would become one in which actually Brown does. That's a product of all sorts of changes that took place. So that's inherent. I think, interestingly enough, the shift from process to substantive theories is explicable, and this would be my answer to your question. The reason you started with process theories is, as I say, this whole thing is driven by the move to judicial supremacy. That's when you need, and you have to justify why this clearly undemocratic institution is going to have this power, and process explanations are the obvious way to go. I think the emergence more recently of substantive theories is just a reflection of the fact that we've all gotten so comfortable with that now, that the natural inclination to actually want to think about substance and not just process has, for some people, emerged. At least it's just not controversial. So, and that goes to me, the reason I would not put any specific directions in there is I think this process of evolution is all inherent, and that would include theories of constitutional interpretation, rules of interpretation, and I actually, if we could bind ourselves, wouldn't want to lock that down. I think you need that room, and that is one of the things that as I say, the text, the Constitution is only a starting point at any given time. That itself is something that's reflected in a multiplicity of practices and beliefs out in the society. And so we're constantly trying to make sense of those. And efforts to kind of lock down our ability to do that with interpretive limitations, I would think would not work terribly well in that sense.
I think we have time for one final question before our reception. So, Daniel.
Thank you so much. My name is Daniel Kim, second year here at the law school. My question is about indeterminacy of open texturedness of the provisions of the Constitution. I think I noticed that the originalists or Dworkinian or non-originalists, they often hinge on this difference a lot, like how clear they think the provisions are. And I'm wondering, in your a book, whether this indeterminacy plays a role in choosing a theory.
Okay, so great. So I think it goes kind of in the other direction. So whether there's indeterminacy depends on what your theory of interpretation is. So there are some forms of originalism that breed a lot of determinacy. So if you're an original expectations originalist, there'll be a lot of determinacy. Was there an original expectation that the Equal Protection Clause would forbid sex discrimination? No. In fact, it's the Equal Protection Clause. It's not the Equality Clause. So it might not even have anything to do with discrimination. Privileges and Immunities Clause might, if this is kind of nerd constitutional law forgive, Privilege and Immunities Clause might have to do with that, but what's the scope of that even? The original understanding might tell you. Now, if you're a semantic originalist, there's indeterminacy. I think the technical term is out the wazoo. If you're a public meaning originalist less, the originalist might say there's a construction zone in which there are things to be figured out. If you're a Thayerian, there's relatively little indeterminacy, because for Thayerians, unless there's, and Thayer didn't notice, he needs a theory of interpretation to bottom the idea whether there's clarity or not. But there are things we can do. Thayer leads to a lot of concrete results. And I think we can go through the list to see how much indeterminacy we have. You might say that if you have indeterminacy, then you become a Thayerist. So uphold it unless it's clearly. Or you might be an Ely type. So this is who would say what Ely types would say. So this is just to say that indeterminacy will be an artifact of the theory of interpretation you choose.
Thank you.
I would say, as to indeterminacy, originalists have different responses to this, but this is my originalist perspective on it, is that the prospect of indeterminacy shouldn't worry originalists, because originalism just says that you should follow the original meaning of the Constitution when it's determinate. And so if it's indeterminate, you need a theory of what you do then. But it seems to me, again, many originals disagree with this point, but it seems to me that as you anticipate where I want to go with this, is that where the original meaning is indeterminate, then the challenge to government action fails, because what gives the courts license, authority, to overturn the decisions of the democratic polity is the enacted law that's in the Constitution. But if the enacted law in the Constitution isn't clear, then the courts don't have the foundation to do that, and then the decision defaults to the democratic polity. So I think originalism can resolve the problem of indeterminacy relatively easily, and it may be that the result is that we are back to most of the more specific provisions of the Constitution, to really the places where the courts are going to be doing most of the activity. And if that's the answer, I think I can live with that.
So with that, please join me in thanking our wonderful panelists and Professor Sunstein for being here.
That's great. Thank you.
I want to point out that there's going to be a reception right after this, so for those of you who still have questions, there should be an opportunity to discuss it. And Michael, is the reception outside? Yeah.
And it's not raining.
Yes. Please come to the reception.
That was great. I was touched by your nice words.